Hi guys, this is Sharifa Tharp with ST Law Office, and today we're doing Ask an Immigration Attorney Live. So I am going to be answering your questions today. Just go ahead and ask your questions in the comment box, and I will answer your immigration question on the spot. So I just want to give you a little disclaimer. I will be answering your general immigration questions today. However, I will not be providing you personal legal advice. If you would like personal legal advice, then I recommend that you call my office and schedule a consultation to discuss your particular circumstances. However, I can give you a general immigration information based on the current immigration law, which will give you an idea of what direction you need to go in, or kind of help with your decision-making process in your case. So let's go ahead. Today, I want to talk to you about how to apply for a green card while you are in the United States. Right now, we're facing a lot of travel restrictions. And in addition to that, the administration has barred the issuance of any green cards of any individuals coming in from outside of the United States. So as we go into problem solving mode, we have to figure out then what is the best avenue for you to take to stay in the United States and apply for your permanent residence here. So I have, I'm going to discuss three different options, and I may cover more if I have time. I'm going to discuss the U visa, the T visa. I'm going to touch on VAWA and the adjustment of status process through our immediate relatives, such as permanent resident relatives or U.S. citizen relatives. So let's start with something called the U visa. If you haven't heard this before, I'm going to go ahead and explain it to you. The U visa is available to victims of certain crimes. So if you're in the United States right now, you're undocumented, and you, while, for example, living here, you became the victim of a certain crime, which is called qualifying crime, then you may qualify for the U visa. And the good thing about the U visa is that you gain status here, you get work authorization, and there's also an eventual avenue to citizenship. So you become eligible to apply for permanent residence, and then from permanent residence, you can also apply for citizenship. So, you know, it's outside of the typical avenue of coming through employment or coming through relatives. I'm sure not everyone wants to have this option just because it does involve the painful aspect of being the victim of a crime. However, you shouldn't have to sit in the United States undocumented without status and suffer suffer as a victim of crime. So it is available for those who have suffered from being the victim of a crime. So I'm going to go through the qualifying criteria to apply for the U visa. So you have to be the victim of a qualifying crime, which I said before. You have to have suffered substantial physical or mental abuse as a result, and you also have to suffer some trauma, and that can involve physical or mental trauma as a result of the crimes. And I'm going to go ahead and list the types of criminal activities that would fall under the qualifying crime under the U visa. So you also have to provide information about what happened, about the crime. So you have to have some kind of information regarding the crime. You have to cooperate with the law enforcement during the investigation of the crime, because one very, very important aspect of the U visa is that law enforcement has, or the prosecuting body has to provide certification that you were helpful during the investigation of the crime. So that's very important. In addition to that, the crime must have occurred in the United States, or it must have violated US laws, and you must be admissible. So when I say you must be admissible, that means that you must not have had any previous issues that would render you, basically bar you from coming into the United States. However, even if you're inadmissible, there is still the option of filing for a waiver to come back to the United States, or to still qualify. So if approved, if the waiver is approved, you would still qualify for the U visa. So if you've had immigration problems in the past that has rendered you inadmissible, for example, if you have unlawful presence, no worries. We can still explore the option of a waiver, right? So I mentioned before the types of crime, because it doesn't necessarily know there's a broad range of crimes that can cause physical and mental repercussions, right? However, so the list I'm going to give you, the example of crimes I'm going to give you, it's not an exclusive list. They can be similar crimes. That's why it's super important to make sure that you consult an attorney to help you to figure out whether the crime that you were the victim of, if that crime qualifies, because it's not necessarily on the list that I'm going to provide to you. So this involves the types of crimes. It's going to be kidnapping, physical or sexual abuse or contact, blackmail, domestic violence, extortion, false imprisonment, felony assault, fraud, forced labor, manslaughter, murder, perjury, rape, stalking, and as I said before, the catch-all or similar crimes. So if you have been the victim of a crime, you would like to seek status in the United States as well as work authorization, please, by all means, get the help you need to do that. I'm going to go on to some of the benefits of the U visa. So in addition to qualifying as a victim of a crime, you qualify. Your family members may also qualify, and I'm going to list the family members that qualify. So the individuals who also qualify for the U visa, if you're under 21, it would be your spouse, your children, your parents, or your unmarried siblings under the age of 18. And if you are over 21, it will be your spouse and children that also qualify for the U visa. So the U visa, I know one very important aspect of any kind of immigration process is how long is this going to take? One benefit of the U visa is that if once you apply, so there's a 10,000, they hand out 10,000 U visas per year, right? And that's, compared to the number of applications, 10,000 in 1 year is not a lot. So some people are going to be left out in the cold. However, there's the added benefit of those who are left out in the cold. get placed on a wait list, and then there is deferred action, meaning that they're not going to take any action on your particular matter. You're on a wait list, and it's kind of like a first come, first serve basis. So you will be provided the U visa in the order you came. In the meantime, though, you will be, once there's deferred action, once you're placed on the wait list and there's deferred action by the Department of Homeland Security, you are eligible for work authorization, and you are eligible for work authorization until the application is processed, until there's a decision made on the application. And once you're approved, of course, as the petitioner, the main applicant, you would automatically get issued your work permit, while your family members would be eligible to apply for their work permit. So that's the benefit, is while you wait for the U visa to be processed, you get to apply for your U visa. Of course, the one downside is that with 10,000 being handed out a year, of course, there's going to be a long time waiting, but you could still move forward with your life, obtain a work permit during that wait period, okay? Now, the other thing is that you would be eligible for an adjustment of status to obtain your permanent residence, which is also a great benefit of the U visa. So after 3 years of after you finally receive the U visa, after 3 years of having the U visa, you can go ahead and apply for your permanent residence. And you don't have to leave the United States to go ahead and do that. You can stay in the United States and do an adjustment of status and get your permanent residence that way, which is awesome. So, and your family members that also receive the U visa would also be eligible for the green card. So you'd have to make sure that you obtain your, after 3 years, you submit that as well as all the evidence to show how long you've had your U visa. You must have been continuous presence in the United States on the U visa to get the green card. In regards to inadmissibility, you have to just make sure that you haven't committed certain crimes, some of which have been murder, torture, or Nazi crimes, right? If you're a Nazi. So other than that, there are not that many bars to the adjustment of status process for U visa applicants. Yeah. So that is one option. And the other option is the T visa. The T visa is very similar to the U visa. The difference here is that the T visa is for sex trafficking and labor trafficking victims. So if you have to show then that you were the victim, you were a victim of sex trafficking or labor trafficking, you have to also show that you would suffer extreme hardship involving unusual and severe harm if you were removed out of the United States. But it's very similar to the U visa. Your certain family members, depending on your age or depending on the circumstances, would be eligible for the T visa. And then there's the ability to get work authorization. Now, I didn't mention this before, but the U visa is authorized for 4 years, and so is the T visa. The T visa is also a path to citizenship. So you go T visa to permanent residence, you'd adjust status similar to the U visa. and then you would apply for citizenship after a number of years. So 5 years, you would then be eligible for citizenship. So the definition of the sex trafficking and the labor trafficking is I wouldn't just count if I were you, I wouldn't count myself out. If you say people tend to think of sex trafficking and labor trafficking as something that had to involve maybe physical restraint, maybe some sort of torture or beating, and it's not as narrow. So it could involve coercion to work. So for example, if your employer says, if you quit this job, I am going to report you to the immigration office, that in itself could possibly qualify for labor trafficking. So it doesn't necessarily have to be an act of outright violence against you. So what I'm trying to say is make sure that you explore your options thoroughly, and that's what I'm here for. If you would like me to assist you in really figuring out if your circumstances qualify you for the T visa or the U visa, please, by all means, give me a call. In addition to that, the certification. So in order to qualify you for the U visa, you have to get certification from the law enforcement or prosecuting body that you were helpful in during the investigation of the criminal matter. In that case, I do also assist in getting the certification. So I advocate for my clients to get that certification and get everything in line to qualify you for whichever visa, so the U visa or the T visa, because the T visa also requires that you're helpful to law enforcement. So I urge you to get assistance in figuring out if you qualify for that. As I said before, I like to choose these topics to educate you about what options are out there while I'm doing this show. I take the opportunity to talk at length about these immigration issues and different paths that you could take to qualify for permanent residence in the United States. But please don't hesitate to go ahead and type your questions in the comment box. So great. So I see one question here, and that's Chandeli Jackson. Hi. I'm just going to put your question up here. So after your application is approved, will it stay long at the visa center? So if it has, I'm assuming this is the petition that has been approved at the USCIS. And once it is approved, so if you are the relative of a United States citizen, there is no wait period to get the green card. So about 3 to 4 weeks after it is approved by the USCIS, which is, in short, I like to call it the Immigration Service. They're the ones that process the initial application. About 3 to 4 weeks after that, it is sent to the National Visa Center. The National Visa Center then sends out a request for additional required documents. And then the National Visa Center, which I'm assuming that's what you're saying. So the National Visa Center then sends it to the embassy for the final interview. Now, this is what I find. I make sure I act very quickly, and I advise my clients to act very quickly to get all that the Visa Center needs Because once the visa center gets it, I would say about 4 to 6 weeks after the visa center gets it, and it really depends. So my experience has been 4 to 6 weeks, but it really depends on what's going on right now, the circumstances, how backed up they are, which I'm pretty sure they're probably very backed up because of the delays and the closings here, and as well as probably at the National Visa Center. But I find that the Visa Center usually sends out, it's like a request for documents about 4 to 6 weeks after they receive it. And that's where it's really up to you on how long or quickly the process can be completed. So if you get all the documents in very quickly, the Visa Center usually sends all the completed documentation to the embassy within another 4 to 6 weeks. And if you haven't sent everything in to the National Visa Satisfaction, they will send you further communication reminding you that they need additional documentation from you. And you usually have a year to get it into the National Visa Center. So I would say it really depends on you. If you get all your documents in ASAP within a week or two, I would say within the next 4 to 6 weeks. But please keep in mind that we have a lot of delays and backlogs going on. But during the ideal time, pre-COVID, it was 4 to 6 weeks. Now it really depends on, first of all, it depends on the embassy in your country. It depends on the visa center and how backlogged they are. But once you get everything into them, then of course their next mission is to get it to the embassy. And in an ideal world, with the embassy being open and the visa center being open, usually within 4 weeks, they'll send it to the embassy, and then the embassy takes over. You'll usually get an interview scheduled at the embassy, which means that the embassy got the documentation, and you would be good to go at that point. So my advice is just make sure you are quick on your feet and you get everything in. If you have any issues with getting documented or please go ahead and give my office a call. I will assist you with what your process. You call and schedule. Great. I'm so sorry about that. I just lost my internet connection, but I'm back, and thank you, Pennis Pickens, for this question about notice of intent to terminate. I-751, is it new? Okay, so the I-751, so that goes back to the conditional permanent residence. So, and it's based on marriage to either a permanent resident or a U.S. citizen. If you do not file an I-751 before the conditional permanent residence expires, then your status as a permanent resident is terminated. So it's very important that around 90 days before the conditional residence expires, that you submit the I-751 to prevent that. It is not a new process. It has been something that it was implemented years ago. However, if you're having an issue like that, then definitely get legal assistance, because if the I-751 is not filed, then of course the next step would be removal proceedings in immigration court. It's super important to go ahead, because there's no real appeal. So in addition to that, I just want to explain a little. You're welcome. I'm just going to explain a little about, okay, great. The I-751 must be filed with the spouse. And if you are unable to file with the spouse, then you can file by yourself. However, there is another process to be able to file by yourself. So you have to show that you've been divorced, that there's a divorce, but the marriage was bona fide, that you would experience extreme hardship if you were removed, and if you are a widower. So if your spouse passed away, that would be another way. In addition to that, I just want to explain that the intent to terminate is not the end of it all. Immigration court doesn't necessarily have to be a bad thing. It just means there's an extra process that you'd have to go through in immigration court. It's intimidating, but the same arguments I just discussed could be brought before an immigration judge, and you could then be approved if the judge sees fit to continue with permanent residence in the immigration court, because there's this. So I just wanted to mention that because that's where it just gets a little more complicated. If you need assistance, please, by all means, give me a call at 561-454-8889 to schedule your individual consultation, so I can help you further with your particular circumstances, because the whole thing really just depends on what's going on in your particular circumstances. Thank you so much for those questions. And I can't believe my time is up. I thank you again for your questions. These were really good questions. I'm so happy that I got the opportunity to talk to you about those issues, because especially the I-751, it's a very common issue. So I'm glad I got to touch on it a little bit. If anybody who's watching this, if you're having an issue with it, please make sure before your conditional permanent residence expires that you go ahead and consult an attorney to get that application in. But it just avoids a whole bunch of hassles. Oh, thank you so much. I'm so glad that I could help. That's what I'm here for. And if you need anything further, you know where to find me. I'm also going to be doing this live again on July 26th. So you can catch me again. If you have any other questions, please check in, and also share this with your friends, your family, acquaintances, people that you know have questions themselves, because that's what I'm here for. I'm here to help. All right. Thank you so much, guys, for your questions. I'm very happy that I could help you out. All right. Have a good one, guys. Bye.